computer because it has software and have the memory functions and is working based on the memory chips. And if the tampering is done and it is having software based on which this mobile phone works, because at that time the mobile phone was of such a high quality that even you can watch TV live on that mobile phone. So this kind of quality mobile phone was there. So they were easily able to prove that this is a violation, and court held that alteration of the software code constitute an offense. Right now, the question will come that if somebody is making a alteration with the ATM machine, whether that could also be covered under this. So if you file a case, the other opposition will raise an objection whether ATM is a computer, right? So in some cases in other jurisdictions, ATM is also considered to be a computer. So whenever any tampering is done with a computer system, and wherever the source code has been established, then a punishment can be imposed under this section. Then we have section 66 that talks about fraudulent acts. 66 can be read with 43, right? Section 66 is, punishing criminal offenses, which are mentioned under section 43. So section 43 is a very comprehensive section, and this is only one section which have covered all the types of civil contraventions under the IT Act. So if you commit any civil contravention under section 43 with criminal intention, that is, you do it dishonestly or fraudulently, and the computer system is involved, or you take any unauthorized access, or you do data theft, then you could be punished under section 66. So take an example. If any computer system is there, right? if you if you access that computer system, is it an offense? Or if the access is unauthorized, is an offense? So access to the computer system is not an offense per se, but if it is unauthorized, right, there is no authorization. Authorization doesn't means that you need to give a written authorization. It could be friendly authorization that generally we give it to our colleagues, and maybe husband give to his wife as well. So that could also be covered under this. But if there is no authorization, no matter any loss has happened or not, no matter any damage has happened or not, it is cyber contravention. And if it is committed with an intention, 66 would be applicable. This could be explained with the case of NASCOM versus Ajay Sood. So this case of NASCOM versus Ajay Sood talks about a phishing case wherein a phishing scam has been done by an employee of an agency. He used to work for giving employment, and he has been an employment agent, right? And used to give news or information, or used to share CVs to the organizations in way. And this person has created a phishing page of NASCOM, and phishing page is created also with the tampering in the source code and making some changes in the back files of the computer language. And if somebody log in through this phishing page of NASCOM, the user ID and password used to go to the person who has created it. When the NASCOM came to know about it, they filed a case. Investigation was done, and court acknowledged the liability of deceptive electronic communication, which was very very similar to the communication page of NASCOM, and the person was held liable, right? Similarly, any employee, if he secretly copy confidential data for the competitors, he will be held liable. Being working in an organization, being an employee, you used to take the data of the organization so that you could have some parallel business, or some maybe small business. Then it could be covered under this. So 66 is very comprehensive because it covers all the types of contravention which are covered under section 43, which include access, unauthorized access, making change in the computer system, inserting any virus in the computer system, making any alteration, making deletion, adding anything, alteration of any type could be covered under this, right? Or even establishing any communication with the computer system without authorization is covered under this. It doesn't require that you need to physically touch the computer system. Virtually also, if you are accessing the computer system by any software or by through LAN or internet or Wi-Fi, could be covered under this. Then we have 66C. 66C talks about identity theft. So this section punishes if anybody fraudulently use another's electronic signature, password, or identification data. Right? Maybe my picture is used by somebody to create a Facebook page. So it protect digital identity of the person as a property. Right? For example, if you somebody use stolen biometric logins of someone to get an access to the bank account, somebody try to take the password of someone, if he is, this is possible through many ways. Manually somebody can get an access of the login id and credentials of someone else, or there is a software also that is called as brute force attack. There are software available in the market through which this software makes attacks to the user id of someone of this many number, that through permutation and combinations they are able to crack the user id and password. And specifically for the Indians, because we have the password very weak passwords. We use the password like mother name or city name with combination of some numbers, or our nickname sometimes we are using with certain numbers and figures. Software is easily able to crack it, right? But if somebody do that, then it could be covered under identity theft. Cracking the login is not covered under this. If you use the credentials, then it is covered under this, right? If you crack the login of someone, then 43 and 66 are enough to address this, right? So along with 66, you can add 66D, 66C for taking an action. 66D talks about personation. It criminalizes deception through electronic communication. If you deceive somebody on electronic system, maybe any chatting website or maybe social media platform, then it could be covered under this. And it is very common in phishing and fake investment schemes, right? Because if you have to ask somebody to log in through the phishing page, you need to deceive the person, right? You need to make friendly communication with the person, and then only if you ask him, he would trust you and add his login id or credential details. Or if you have to sell somebody an investment scheme online, then first you need to become the friend through some deceptions, right? Or maybe creating fake government website to collect registration fees from unsuspecting citizens, because you trust government. There is no requirement of creating a deception by the government. So if these fake pages are created and you act on that, then it could be punished under this. This has been addressed in one of the very famous case called Sony Sambandh case in 2004, wherein uh, a person who was an Indian who committed fraudulent use of credit card details of some NRI for online purchase. SonySambandh.com was a website at that time which used to provide services to the NRIs only to purchase electronic goods from USA on some discounts, and the transaction has to be done through credit card. One person done a transaction with another person who was a credit card agent. So he provided the services and got the details of the credit card, and then he created a fake identity called Barbara Campa and used the credit card of that person to make online transaction, showing it I am a NRI and I want to purchase certain goods. He purchased the goods. Goods were delivered also. When the credit card company bill came, it was identified that the person who owns the credit card had never made such purchases. So investigation was done, and the person was prosecuted. It was found that misuse of digital identity credentials is a cyber crime, and it's very complicated. And after that there were a lot of you know notifications were issued by the banks and financial institutions that be aware of such kind of criminal acts which are there in market. 66E talks about privacy rights. So it is not specifically about the privacy in toto. It is privacy of private body parts. So it penalizes if somebody captures or shares the images of private body parts without the consent. So focus is of this section is on bodily privacy and dignity. And this section has been added by 2008 amendment specifically to protect the personality and the privacy rights of celebrities. Because so there were many incidences reported online that people used to take the pictures of the celebrities and either used to try to catch the pictures in such a way that they are able to take images of private parts or some area of private parts of the celebrities and used to sell it in the market. Sometimes they used to make short reels and used to sell it in the market. So this is punishable under the privacy rights. Although privacy rights has been addressed in the case of Justice K.S. Puttaswamy versus Union of India, which recognizes privacy as a fundamental right and form the part of the basic structure of the Constitution of India. So Section 66E is also part of it, and it cannot be amended. It's a fundamental right given to all the citizens. 66F is this section is one of the section which have highest punishment for the crime, cyber terrorism. It covers an act which is threatening national security through computer systems, including attacks on critical infrastructures or unauthorized access to the restricted government data, or creating turmoil in the society, or create hampering the friendly relationship of India with some other states, or publishing news in such a way that this create a hue and cry in the society, could be covered under this cyber terrorism. And also all types of related activities of funding as well as supporting the terrorist activity. If a hacker breaches defense communication network, for example, he is endangering sovereignty of the country. And if you attack the sovereignty of country, it can be covered under cyber terrorism. So this is a very comprehensive section which covers any type of act which is against sovereignty or society's peace, then could be covered as cyber terrorism. There was an incident in the news wherein somebody in Bangalore spread a WhatsApp message to people from northeast in their mobile phone. He sent the message that there are going to be a series of bomb blasts in Manipur. And after the spread of this news, many people who were living in Bangalore, they started rushing to their home state. There was a lot of hue and cry in railway station. It was unmanageable by the administration. Uh, people's bodies were damaged, and there were a lot of hurt also to the people's bodily hurt to the people because of such unmanageable incidents, because of crowd which was more than the sustainable numbers for that railway station. So this was also considered to be cyber terrorism, right? If such activity is done by somebody, it's a cyber terrorism. Then we have section 67, obscenity. If anyone publishes or transmit obscene material electronically, right? Now he could be covered under this. That digital medium need to be there. Then court can apply community standards to determine the obscenity. Very recently, there was a case of publishing such content, even verbal content. If it is published, it could be covered under this. There is a case called Sharat Babu Digumurthy uh, in 2017, wherein in Sharat Dagumati, a company's director was prosecuted for obscene content which was uploaded on his website. He was punished under IPC, read with section 67 of Information Technology Act, and Supreme Court also held in this case that 67 to 67B Act constitute complete code for electronic obscenity. So 67, including 67A, 67B, this covered almost everything about the online obscenity. And in this case, the reasoning that has been quoted is that Parliament has created a special law for cyber offences with respect to the obscenity. So therefore, IPC provisions can be applied simultaneously along with this. So this will prevent obscene content, publication or spreading of obscene content. 67A talks about explicit media, which address more serious sexually explicit material online with higher punishment. That is, called as section, punishing cyber pornography. Now, in this case, if you publish any pornographic content online, you could be, punished under this section. And this also, can be applied with the IPC or BNS. We can address this with the help of Kamlesh Vaswani versus Union of India in 2016, wherein a PIL has been sought for the a nationwide ban on internet pornography. So court refused a blanket censorship. They said that it has to be addressed case to case basis. So total blocking would violate the freedom of speech and expression, because everything that is obscene for me may not be obscene for you. And practically it would be impossible for to enforce such kind of ban. So there must be a regulation uh, which will address the issues of cyber pornography. So IT Act section 67A read with 67 and 67B is sufficient enough to address that. If it is done by someone to publish or spread online content, then it is violation of the IT Act. So it recognizes the limit of the state in regulating online content and reinforce the reliance on 67A. Then we have 67B, which is more heinous crime, that is child pornography. So this criminalizes creation, possession, browsing, or distribution of child exploitation material. So this is one of the most stringent cyber provision, and we can understand with the help of Just Rights for Children's Alliance versus S. Harish in 2024, which introduced the doctrine of constructive possession. Now, in this case, it has been examined that whether viewing or downloading child sexual exploitation material amount to the possession or not. Now, with respect to this case, even if you are, viewing such content is punishable. The Supreme Court held that viewing such material constitutes the possession for that time period, because digital access create a constructive possession, because the user exercises the control and contributes to the exploitative ecosystem, right? So why are you watching that? So Supreme Court has serious note on this, and they said that it is to be applied even if somebody is watching for even a time being. So this has strengthened the law relating to the child pornography, read with POXO. So in addition to the POXO, this section can be applied. So this is very strictly implemented for the prohibition of any activity which is related to child pornography, and also a caution for the pedophiles that no attempt should be made specifically in this country which is relating to the child pornography. 69, section 69 talks about the surveillance authority of the government, and it allows the government to intercept, monitor, and decrypt digital information for national security or public order. and also raises significant constitutional issues with regard to the individual privacy and principles of proportionality in the state surveillance. This power is given to central government, so it is a exception to the right of freedom of speech and expression, wherein government can intercept, monitor, and decrypt any data, or even the whole traffic which is there on internet. If you say that I have private WhatsApp message and WhatsApp chat, government is not going to see that. But if there is some reason to believe that it is going to disturb the public order, or it is against the national security, then government gets the right, and they can ask even Meta to share the information relating to that. And this has been done by the then government, recent government, many a times. Then we have section 79, which talks about the intermediaries liability. Now this provide a safe harbor to intermediary platforms, or platform service providers. If the service provider has done due diligence, or if any crime or offense has happened in its platform or through its platform without his knowledge, then the platform should not be held liable, right? And this also has been, explained in the case of Shreya Singhal versus Union of India in 2015, which clarified that intermediaries if they remove unlawful content, then action directly should not be taken against them. So reasonable time should be given to them, and based on that, only they should be held liable. And they need to remove the content only upon the court or government order. This case has also been very dramatic in case of Avinash Bajaj versus Delhi administration around 2007, wherein some pornographic content has been uploaded on Bazi.com. Bazi.com was a subsidiary of eBay.com, which is a US company. In this Bazi.com, the pornographic content carrying some sexual activities of the children's who were studying in the Delhi public school, it has been uploaded. And based on the FIR filed by the parent, an action has been taken against the CEO of Bazi.com. However, when this case went to Supreme Court, he was acquitted on the ground that the provisions was not very clear as to the limit of the liability and due diligence that need to be done, because this regulation says that if the person followed the due diligence, then he should not be held liable. But how much due diligence? Do we have any limit to the due diligence? So due diligence provisions, it has been mentioned in section 79 that as may be prescribed. So government didn't prescribe the rules with respect to the due diligence since 2011, and this case was of 2007. So could not held them liable. But since 2011, it has been defined that what is due diligence and how much due diligence need to be done under the intermediary rules. So if a company or a platform is not complying with the intermediary guidelines, then they will lose the safe harbor and they would be held liable, right? And this is applicable to all the applications which are providing online services. Then let us spend some time on BNS provisions. So BNS also have the provisions with respect to the cheating, uh, which was there in the IPC as well. That is, section 66D. So BNS also covers the cheating where deception include property transfer, or fake websites, or fake images, or manipulative digital identities, or fake videos are being created. So any person who involved in such things can be jointly punished under BNS as well as section 66D. Cyber stalking is also now covered under the BNS. If it criminalizes if somebody is repeatedly monitoring or surveillance of of a person against his will. And this has also been discussed in the case of State versus Muhammad Imran. Now, in this case of State versus Muhammad Imran, the accused repeatedly harassed a woman online, and used messages and sometimes fake accounts to follow that girl, and used to threaten with his wording in the messages that he know what relationship she had, or so and so things he used to mention, and she filed an FIR for that. And court held that this is stalking, and because you are disturbing by stalking mental peace of the person and her personal liberty. So the reasoning which has given that digital surveillance and repeated online contact amount to psychological intrusion and threat to the liberty of the person and can be covered under the BNS. And this demonstrates the application of stalking provisions are punishable online, right? If somebody don't want to talk to you or don't want that you should follow, then if you do repeated actions, it could be covered under cyber stalking. All right. However, this doesn't mention how many numbers of attempts need to be made by the person. Then it could be covered under stalking. Maybe once, if somebody stalks someone, then it is not covered. But twice or thrice, if after saying no, it is repeated, then it could be covered under this. Online defamation, which was there under the IPC as well under section 419, 9 and 500, is still retained under the BNS as well. And criminal defamation could be punished. It has been punished in the past as well. We have the case called SMC Pneumatics versus Jogesh Quatra. Now, this SMC Pneumatic versus Jogesh Quatra, an employee of the company, after being removed by the company, he circulated defamatory email against his employer to all the employees. And then when he was prosecuted, company was in Delhi. He said that I am not from Delhi, and case cannot be filed in Delhi because he stays somewhere else. And Delhi High Court granted an injunction restraining the person from sending such emails and delete all the emails. But there was an issue with respect to the jurisdiction of the court as well, whether the jurisdiction, because jurisdiction is defined under Civil Procedure Code, and it has to be fine, has to be action has to be taken where the cause of action arises or where the person resides. But court held that in this case that it is cyber stalking. It is done in a digital space, so it doesn't matter from where it has been done. Case can be filed in Delhi also, and all types of electronic communication which falls within the definition of defamation would be, injurious to the person and can be covered under the IT Act read with the IPC. Uh, then we can address certain cases to understand more about the application of uh, cyber pornography, like Sharat Babu Digumati case, wherein Supreme Court has held that Section 67 to 67B forms a complete code for electronic obscenity offences and prevent overlapping prosecution under IPC and clarifies legislation intent for distinct cyber crimes. If somebody involved in this, it could be covered under the IPC only. Further, in Ranjit Udeshi in 1964, which is a very old case, which introduced the Hickling test in India, it said that obscenity was judged by the tendency to corrupt vulnerable mind, or it is done with a publication of some content which create lascivious thoughts in the mind of someone else, or corrupt his thoughts, and right, with respect to the activities that he watched. So later on it has been modified that it remains the foundational case for obscenity jurisprudence in India. Because in this case, the sale of the book called Lady Chatterley's Lover was objectioned, and it was said that this is a pornography content. So the person who used to publish it was arrested, and conviction was also upheld by the court. And the reason court given is that the Hickling test, that is, the material is obscene if it tend to corrupt the vulnerable mind. So vulnerable mind here is young population, right? So this became a historical foundation. Based on that, we also have little more explanation given under the IT Act to cover the case. In 2014, a weak Sarkar case. A weak Sarkar case talks about election dispute relied on electronic, recordings. So in this case, Supreme Court held that 65B certificate is mandatory for admission of electronic evidences. The Supreme Court moved from to the contemporary community standard test, recognizing the evolving societal needs of today, and societal attributes toward the nudity and art, and vital for the modern interpretation of online and digital medium. So in this case, publication of nude photographs in the magazine would not be punishable per se. It is based on the standards of the society, right? The court adopt the community standard test, and the context, message, and contemporary values must guide the obscenity, right? Uh, then we have the Just Rights Alliance case. So now, in this case, Supreme Court has said that viewing child sexual exploitation material is equal to legal possession. In the court introduced the doctrine of constructive possession and strengthened the application of 67B and POSCO provisions. In another case, Virendra Khanna, it stressed the absolute need for proper seizure on procedure for digital device, and evidence integrity is if and evidence integrity is compromised without strict forensic guidelines or forensic safeguards and constitutional procedure with respect to the compliance. So this is important that whenever material is produced, it should not be tampered. There should be certain standards that need to be kept. In case of Madhukara, regarding the electronic evidence, in this case also, Supreme Court has addressed the issue of the custody of the material. So, wherein the challenge was there to the prosecution due to improper custody of electronic evidences. So, court emphasized that the handling of the material should be done, with certain, proper guidelines, right? And court emphasized that chain of the custody is required. That if any chain of the custody is tampered, then it will not be admissible. So they said the breaks in the custody undermine the reliability of digital evidence, right? So whatever digital evidences are there, maybe for every obscene material or obscene content, it should be produced as it is, and forensic check need to be done. Otherwise, it will be objection. In Anwar PV, Anwar PV case, Supreme Court has held that 65B certificate is mandatory, which is now retained in the BSA as well, wherein the court was with respect to electronic recordings that we have, I think, already mentioned. In Arjun Pandit Rao, so now Arjun Pandit Rao case is also important with respect to electronic evidences and admissibility of electronic records in the court of law, wherein the question was on whether electronic evidence can be admitted without certificate or not. So court reaffirmed that the Anwar rulings, and they said that certification is mandatory unless original device is produced. If you are producing an original data or original device or content without sharing in the chain of custody, no problem, right? If there is a chain of custody, then certificate is mandatory, right? So this cannot be changed. So it clarified the procedural compliance to ensure the digital evidence remain reliable and untempered throughout the legal process. Then let us talk about the cyber security strategy that government of India has. So there is a national cyber security strategy which has been proposed very recently, which adopt a structural approach towards three pillars: mainly secure, that is technical protection; safe, that is citizens protection; and resilient, that is business continuity. Because at the end we are living in the ease of doing business era. So it focuses on indigenous tech and international cooperation. So there are many institutions which are created after the IT Act, as well as amendments of the IT Act in India, to provide digital safeguards and cyber security, and also to ensure cyber security standards and maintain a cooperation and a uniformity of cyber security measures in India. Although for the security concerns, government of India along with the state government also have the right to intercept the data and also block the website or content if it is there online through the notification. And there are also a lot of sectoral regulators, right? So sectoral regulators include Reserve Bank of India, which is basically issuing guidelines and notifications for the banks and financial institutions. And continuously they issue guidelines that customers also need to follow. Like for example, a very important guideline which Reserve Bank of India has issued, that when you use net banking, should not use keyboard, always use digital keyboard, right? And uh, another notification that Reserve Bank of India has issued for all the banks to implement is that do not share your OTP with anyone, and without any reason any bank or financial institution never call you to ask your OTP or your this CVS number. SEBI, on the other hand, is regulator of capital market and capital market intermediaries, including brokers, merchant bankers, financial institutions which do buying and selling of shares. They also provide for proper KYC before opening any trading account or demat account. You need to do proper KYC, and standards need to be maintained by the intermediaries when they are providing digital services. In telecommunication sector, we have a TRAI, Telephone Regulatory Authority of India, which is also responsible for providing you internet services through mobile phones. So they also continuously publish notification and guidelines to have safe internet access. Institutional governance specifically relies on Ministry of Information Technology and computer emergency response team. So computer emergency response team in India have an MOU with all the computer emergency response teams all around the world, because it's not a unique institution in India, it's there in other countries as well. So whenever any cyber crime or incidents happens in other country, it is also shared with India so that India get prepared. Certain also given advisory to the government with respect to any cyber crime which is happening, and the government need to intervene. Like for example, if during this COVID-19, there were a lot of fake news spread by the people on YouTube and social media channels. Given an advisory to the government that this need to be addressed, and government issued a notification through the certain that there is no requirement of panic. There is a standard protocol that you have to follow, and all the services to the citizens will be provided through these channels by the government. Similarly, I4C is the part of Ministry of Information Technology, which provide for a platform to file complaint online through the digital space. And NCIIPC provide for the critical information infrastructure protection, and Government of India declare any infrastructure as a critical information infrastructure, and if somebody tamper with that infrastructure, then higher punishment can be imposed under the IT Act. So critical information infrastructures can be declared by the state government as well, like Delhi International Cricket Stadium's system is declared critical information infrastructure. Even the traffic light system can be declared, or any system which is using computer technology for its services. So evidence collection is very important, and it includes computer logs, metadata, and whenever investigation is done, it is governed by the BNS and Section 78 of the IT Act, because investigation and cognizance can be taken only by the officer of inspector level, and below that it is not allowed. But still, in states, uh, people from below the inspector level are still continuing the prosecution of the cases. So court emphasizes preservation of the chain of custody to prevent contamination, and failure to follow the protocol compromise the reliability. So it is very important that evidence need to be protected. So government of India, what they have done to maintain a secure evidence, they have created cyber labs and forensic labs in almost all the states. So before producing the electronic evidence, it need to be verified by the forensic lab, and a certificate need to be provided for its reliability. So cyber forensics now is emerging as one of the field of study, and a lot of investment of Ministry of Home Affairs has been done to strengthen the cyber forensics institutionalization in India. So it refers to scientific analysis using tools like hash values, fingerprints to verify the file's integrity, and it will also ensure admissibility of electronic record in the court of law, and to make it reliable and tamper proof if the evidences are to be used. Section 75 talks about the jurisdiction of IT Act. Section 4 of IPC also talks about the jurisdiction of IPC. So the law that we have in India is having global application. If any crime is committed in India by anyone out of India, it can be prosecuted here. If it is done by Indian and somebody goes abroad, then also it can be prosecuted here. If crime is committed out of India and the effect arises in India, then also it can be prosecuted here. So Section 75 grants India's jurisdiction if the computer system is located in India and is affected regardless of perpetrator's location. It could be committed from anywhere, doesn't matter. It ensures that the offenders cannot escape the liability merely by operating from foreign territory. Somebody can be publishing uh, pornographic content, or maybe obscene content, even against the politicians or our personalities, or maybe somebody writes something bad against Mahatma Gandhi as well. So he can be prosecuted in India because the effect is there in India, right? So this global jurisdiction is provided under the IT Act as well as under the IPC. However, we have a comprehensive law, lot of judgments are there, we have precedents which provides a guideline that need to be followed when we prosecute a case. But there are a lot of challenges like a rapid technology evolution. Now we are living in the era of AI. There are a lot of crimes which are happening now driven through the AI, and provisions are silent about it under the IT Act. Government has to intervene very fast and come up with the directions or take actions. Recently, certain cases like deep fake has been innovated a lot, and fake calls, or digital arrest, which has been happening in India by through many jurisdictions. People used to commit crimes of digital arrest, and sometimes extort money also from the people. So it has been cracked now, but a law may not be sometimes sufficient enough to address this issue. Rather, awareness would be more important. So government has created a lot of awareness through the telecom services agencies as well, that be aware of such incidences, and police or anyone doesn't do any kind of arrest through the digital medium. But still, technology is a big challenge because it is rapidly changing, and always a question arises that whether technology should come first or law should come first. But in reality, it happens is it is always technology which comes first. We experience the technology, and then the laws are made. So that is one of the issue. Second issue is a complex jurisdiction conflict, because something which is crime in India may not be crime in France. Like, for example, in France, pornography is legal, but in India, pornography is illegal. So if any website is operated from France or from Russia, and it is not banned here, right? Because when the government say that we will ban the pornography website, so they cannot have ban as it is. They have to give the list of websites or keywords or some content to the internet service providers, and then they will use those keywords to ban the traffic of these websites. But if they are in different language, or there are different keywords which government may not have imagined, then it becomes very difficult. They maybe get filtered and could be accessible in India also. So because of this jurisdictional, conflict, we will not be able to address all the crimes possibly within India. And because of conflict of laws, there is one challenge which cannot be addressed. It will be addressed only by the precedents of the conflict of laws. Then another challenge is extreme evidence volatility, because evidence can be tampered very easily in the cyberspace, and reliability of evidence itself has been a question. So government of India through Ministry of Home Affairs have recently worked a lot in strengthening the cyber forensics and specifically digital forensics, but still it is at a nascent stage. It need to work a lot in this area, so that is one of the key challenge. And the fourth is balancing security with the privacy concerns, because when the government want to impose security or sovereign authority for to keep the nation secure, it conflict with the privacy rights, right? For example, for the security, we need to ban certain websites. Somebody who's operating this website, he would say that I have a privacy right. If the government of India bans some Facebook pages or Instagram or Telegram pages, somebody will say that we have all the rights to freedom of speech and expression. And when the government bans such pages, sometimes the genuine pages are also banned because they use filters, right? This happened in the case of no case of defamatory content published on the Facebook against Manmohan Singh. So government banned all the pages with in the name of Manmohan Singh. So they given the instruction to Facebook to delete all the pages. But there were many pages created by the people in the name of Man.Mohan, Mon Mohan, and Manu Mohan, and so on, so on. Many words were used similar to Manmohan Singh fake pages. So it becomes very difficult and challenging for the company also how to identify all those pages and delete those pages which are fake in the name of Mr. Manmohan Singh. But with the help of AI now, it has become easy. So this has been an incidence of 2010 around, wherein it was difficulty was faced by the companies. So when the government want to have strong security practices, it become a hindrance over the business community, because they want to provide a platform where anybody can say anything. And also citizens wants a platform where they are able to speak anything on the platform. So this is one of the challenge, that how the balance need to be created in the regulating cyberspace. And last point that I would like to conclude with this is future directions. So for the future, these are my submissions. You may have your own views on that. We need to have a strong cyber infrastructure laws. We need to have some more laws which give a tooth to the organizations. For every sector in the cyberspace, we need to have specialized organizations to address the issues. We need to have establishment of specialized cyber courts. If you see, the cyber specialized courts has been established in India since 2000. Two, we had Cyber Appellate Tribunal, but if when you visit to the website of Cyber Appellate Tribunal, you will see that hardly only 10 to 12 judgments has been passed by the tribunal in the span of like 15 years, 15, 16 years. So the success rate of prosecution has been very low. So is it possible that are you able to accept it that we have very less cases of cybercrime in India? There are many incidences, but people do not report it, or they may not have the knowledge how to prosecute a case. So we need to have specialized courts within different states, so that actions could be taken easily, and training also should be provided to the police so that action should be taken. There is requirement of enhanced international cooperation mechanism. Yeah. Hello, any question? And the last point, that is indigenous technological development should be there. We are relying more on the technological developments which are happening from other countries like China and US. So there is a lot of threat with respect to the data that we have to compromise with them when we are using their application. So to conclude, I would say that cyber law represents a vital fusion of criminal law, technology, regulations, evidence law, and constitutional rights. So we have very strong legislation, but there are still certain attempts which need to be made to strengthen it, right? And with this, I would like to end my presentation, and I'm open for the question answers uh, from all the participants. Thank you very much.
Thank you, sir. It is a nice presentation, sir. Uh, Dipankar, sir.
Yes, sir.
Yes, sir. So, sir, whether we are going to continue with the same session for the validatory session, or we can go
Uh, we'll,
for
we'll start from 5, sir, as chief guest
stuff for
arrives.
five.
Has chief guest arrived?
Yes, sir. Yes, sir.
Or then we can continue.
Okay.
Then
So,
we'll first
we can,
have the vote of thanks.
okay. Then before that, we can, let us see whether our participants want to ask any questions.
Okay, okay.
So I request all the participants to unmute, and if you have any queries, please you can directly ask the question, or you can send it to the chat box. Yes, one question has come. Sarthak Sharma, sir, which other laws cover such procedures?
Okay, so cyber law, when we say the primary legislation is Information Technology Act, because it comprehensively cover all the types of offenses and crime, but it has to be read with other laws as well. For example, when there is a case of tampering with the check, or or financial instruments, then we have to see Banking Regulation Act and Reserve Bank of India Act. When it is tampering with your demat account or your trading account, we need to check into the guidelines of SEBI. If it is a digital payment of illegal money, then PMLA need to be referred. And also BNS, when it is a crime, definitely BNS will automatically will be applicable, because the provisions of BNS are enough to cover up all the types of crimes which are happening in cyberspace. But IT Act specifically covered that, and specific punishment is there. So both are read together.
Is there any other queries from any participant?
There is one question by Miss Meghana, that you don't
Meghna,
have any gap between cyber laws and fundamental rights. So there is no gap, because fundamental rights are our constitutional rights, so they cannot be compromised. However, there are certain exceptions to it. So when these exceptions are applicable, sovereign authority can exercise their power under that exception. So we have to read fundamental rights as well as cyber law together, right? How can we balance government surveillance and censorship with individual rights of freedom of speech and expression? Nowadays, a government have absolute rights of protection of its sovereignty. So and we also have the freedom of speech and expression, but if it infringes with the government sovereignty, definitely it would be curtailed. There was a provision 6A in the Information Technology Act, which has given the absolute authority to the government to arrest anyone if he publish anything against the government or speaks which is going against the government sovereignty, this has been struck down by the Supreme Court. But still, government exercises the same power under the power of sedition under the BNS, right? So it could be covered as sedition if you speak anything which is going against the government per se. So definitely, censorship is there on the individual's rights of freedom of speech and expression, but it is only with respect to the infringement when goes to attack the government or government authority.
Another question is there, sir.
Yeah.
Uh,
Uh,
mo- Modern
Well,
approach. Yes.
modern approach to crime and security would be, the government first need to legislate on artificial intelligence, which is still pending. We have enacted Data Protection Act. Its rules are, rules are also there, but it is yet to be implemented. So this modern measures government is taking, but it is yet to come. If we have worked along with the European Union AI Act. I've also written a paper on European Union AI Act, which is a standard law which could be adopted by other countries as well. But there is no attempt as of now by the government of India to regulate AI uh, with any legislative measure. So this could be a new, modern way through which they could regulate.
If another question has come, sir, from Magna Reddy.
Yes, yes.
Sir,
Let me
what
read
is
the question. When a bank account is frozen anywhere in India related to cybercrime, isn't it unfair expecting people to travel to a place of complaint to solve it? I'm not able to understand the question. I think it need to be rephrased. Maybe you want to ask that when a bank account is frozen, so where would you need to file the case? Is it unfair that if suppose you travel to some place for tourism and there the account is uh, frozen? Are you want to say that? I think if you could rephrase the question, it would be helpful. Or
I
if you could
request?
unmute or speak.
Yes, yes.
What,
So Magna has reframed the questions. If my bank account is frozen in Assam due to funds sent by my and I'm from Andhra.
yeah, so if you have to go to the bank branch because our machinery doesn't work uh, in this way that you are somewhere else and you have to reach to the nearest bank branch, and the bank branch needs to verify from where the fund has came, and they because it's a authority with the bank under the IPC also. If illegal transfer has been made, they can freeze. But if you go and respond to that, and you can claim that it has not been asked by you, definitely this from where this money or source of the money is, you don't know. The bank authority can verify it and can raise a complaint from your side to initiate the unfreezing of your bank account, but doesn't work instantly because it's responsibility of the bank under the PMLA to do compliance. So they have to follow the steps, so it will not work instantly. There is another question as to the framework available to address or combat non-consensual intimate. What is the legal framework to Just a minute. Legal frameworks are available to address or combat non-consensual, intimate, imaginary. So it is covered under the IPC also. So I because specifically there is no provision under the Information Technology Act per se, but BNS covers this, and BNSS also have the procedures through which action can be taken.
So no more question has come. May I proceed for vote of thanks? So it was a nice session, sir. Many queries has come from in this last session. Thank you, sir. So may I now request Ms. Pritisha Chaudhary, Assistant Professor of Dr. RKB Law College, for offering vote of thanks.
Thank you, sir. Am I audible, sir?
Yes, yes.
Good evening, one and all. At the conclusion of today's online session on legal frameworks on cybercrimes and digital security in India, I, Ms. Pritisha Chaudhary, Assistant Professor of Law at Dr. Rohini Kanta Barua Law College, would like to sincerely thank Dr. Amit Kumar Kashyap, Head of Department, Institute of Law, Nirma University, for delivering such an engaging session. Sir has very well explained the topic in a very clear and structured manner, making the session informative for all the participants. I also extend my heartfelt gratitude to all the participants for their active involvement during the session. My sincere gratitude also goes to the organizing committee as well as the principals of both the institution for the constant guide and support. Last but not the least, I'd like to thank all the staff, technical as well as non-technical staff, for their constant guide and support. With this, I conclude my vote of thanks and once again extend my heartfelt gratitude to everyone involved. Thank you, everyone. Have a great evening ahead. Over to you, Dipankar, sir.
Thank you, Pritisha madam. It was a good evening to all, and thank you, Amit Kumar Kashyap sir, for this insightful session. And we wish to hear from you in our future academic endeavors. And for the participants, I would like to announce that we are shortly going to start our valedictory session. And so kindly be present for the valedictory session. So Pankaj sir, are you there?
Yes, yes.
So
So we
sir,
can,
can we start the valedictory session?
For 5 minutes, I need a break.
Okay.
5 minutes.
Okay. Okay.
Okay, we
Sir,
can.
okay. Okay.
Maybe, I think, Dipankar. And the session platform we can continue. Just 5 minute break.
Okay. Okay. 5 minutes break. Okay. Okay.
Okay,
Amit sir, can you be there with us for the valedictory session? I'll request you.
Of course, yes, and also I'm very much thankful to the organizing committee for inviting me and giving me an opportunity to interact with all of you. And I would be very happy to stay connected further. Thank you.
Thank you, sir. Thank you very much.